4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is in session.
Good afternoon, Council. Before we call the case, just a quick reminder that we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and pause, and we will resolve it and proceed. All right, how are we doing the arguments? I mean, I know the appellant first, but who's doing the argument?
Connor, Patrick Riley is doing the is doing the argument for us.
Okay, thank you. We'll hear from the appellant.
Your Honor, may it please the court, my name is Patrick Riley, and I, along with Donald Caparella, Kimberly Waterhouse, and Taylor Jenkins Dowd, represent the appellant, Cathy McKeehan. And I would like to reserve 3 minutes of my time for a rebuttal.
That'll be fine.
Thank you. Your Honors, this case is about the interpretation of a restrictive covenant prohibiting temporary structures and whether or not it prohibits the placement of a modular home onto Mrs. Price's lot. The trial court below erred as a matter of law for several reasons in finding that this restrictive covenant did not prohibit this modular home. First, the trial court failed to follow binding case law requiring it to broadly construe the meaning of this restrictive covenant. Restrictive covenants against temporary structures, mobile homes, and trailers fall into an exception to the general rule that restrictive covenants against the use of land are strictly interpreted. This exception has been applied by Tennessee courts for a long time. And in our briefs, we highlight a line of cases interpreting similar restrictions and giving this broad interpretation. The reason for this broad interpretation in this exception is that courts give these restrictions and interpretation based on the intent of builders to prohibit homes that were built off-site from being placed into subdivision lots. And this exception has applied for a long time and was recently, or more recently, reiterated by the Supreme Court in Williams versus Fox in 2007. Second, the trial court failed to properly interpret this restriction and whether or not this modular home fell within its parameters by focusing on the intent of Ms. Price in making her home permanent rather than the characteristics of the home itself. This line of cases that I've referenced that are outlined in our brief highlight that courts in Tennessee look to the characteristics of a home in determining whether or not it is a mobile home or a structure of a temporary character rather than the label affixed to that home. These mobile characteristics tend to include being built off-site, which falls in line with that broad exception that I referenced, being transported to the lot in more than one piece via tractor trailer assembled on site, having the wheels and the tongue removed. Often the steel frame underneath the home stays in place as it is placed on some kind of permanent foundation, of which there are many varieties. The home here, Ms. Price's modular home, was built off-site. It was transported over the interstates via 2 pieces on tractor trailers. It was assembled on-site, that the 2 pieces were connected. It had the wheels and the tongue removed, and it was, it would be placed on a permanent foundation, very similar to the types of homes that have found to be prohibited by similar restrictions in all of these prior cases. And the trial court even itself stated in ruling from the bench that it is difficult to distinguish this modular home from a mobile home in looking at it. And in our reply brief on page 6, we include a drawing of this home from Ms. Price's purchase agreement. And in looking at this and in hearing the testimony, the trial court agreed that this seems like it is a mobile home and shares all of these characteristics. Yet, if it decided that this home was not of a temporary character, because Mr. Price,
Well, I'm sorry, let me interrupt you here. Our General Assembly am I correct that our General Assembly has determined that there's a distinction between a modular home and a mobile home?
yes, Your Honor. In 1985, the legislature passed the Modular Buildings Act.
And if our General Assembly says there's a difference between the two, what do we do with that? And I understand your argument about the restriction was in 1959 and we have to apply it as then, but if our General Assembly has said a modular home is not a mobile home.
Your Honor, the Modular Building Act does not itself define modular buildings to be permanent. The definition itself states that of a modular building unit in that statute you referenced, states that a modular building unit is a pre-assembled unit, which includes all of the different kinds of utilities within it that can be moved onto a lot. In nowhere in the statute does it say that it excludes mobile homes and temporary homes. The only reference to temporary structures is that it specifically excludes 3 specific types of temporary structures from the definition of a modular building unit. And that's the kinds of structures you see on a construction lot, certain farm buildings, and ready removables, which is like stadium press boxes and assorted buildings like that.
Counsel, let me ask you, are you suggesting then that instead of looking at the definition that the General Assembly has issued, that each one of these cases regarding modular home, mobile home should be looked at separately?
Yes, Your Honor. We're suggesting that based on this line of case law, which was reiterated by the Supreme Court in Williams in interpreting a modular home, each building itself and each type of home needs to be interpreted to determine whether or not it fits within the specific restriction that is applying to it. And these cases have all shown that various types of homes, regardless of the label attached to them, whether they be mobile homes, trailers, manufactured homes, and even modular homes, can fall within these restrictions when they share these mobile characteristics, which I outlined this house certainly, or this home certainly contains.
Was there proof presented that pretty much any house can be moved?
That's certainly true. Due to modern engineering, most buildings can be moved as long as they're not too tall. But the key distinction is whether or not that home as a structure is intended in its creation to be able to be moved. This modular home certainly was designed to be moved in that it was built offsite and designed to be moved onto a lot in more than one piece. Mr. Buell, the salesperson who sold this house to Ms. Price, even stated that it was just as mobile as a typical double-wide mobile home and shares almost all of the same characteristics other than the name. In Your Honors, a prior Court of Appeals opinion from 1995 faced a very similar factual and legal issue. It was Beacon Hills Homeowners Association versus Palmer. In that case, the court was interpreting an identical restriction to this one that had been recorded in 1977 before manufactured homes became a distinct statutorily defined category of homes. And this person wished to place a manufactured home on their lot, and the court was faced with determining whether this restriction, which did not include the term manufactured home, would prohibit that home, which was a type of home that came into later existence. So it's exactly like this factual and legal situation. And the court there did exactly as we suggest, and it looked to the characteristics of the home. It looked at the year and the time in which the restriction was recorded and the legal framework that existed, and determined that the manufactured home, even though those came into existence later in time, was prohibited by this restriction against temporary structures.
Let me ask you, did modular homes exist in 1959?
No, they did not.
So how could but you want us to apply this covenant to something that didn't exist in 1959?
That's precisely the key, is that in 1959, the recorders of this restriction could not have used the term modular. Instead, they had the foresight to say, no structure of a temporary character can be used either temporarily or permanently. And that restriction must be interpreted as of what those words meant in 1959. Manufactured homes didn't exist yet. The common terms back then were mobile home and trailer. But I think it's clear, based on the drawing that we've included in our reply brief and the testimony that was before the trial court, that the parties who recorded that restriction in 1959 would view this home as a structure of a temporary character or a trailer. It is functionally identical to those types of houses, except that it falls into a different regulatory scheme in current times.
What if it was one of these log home kits that you buy, who are actually, as I understand, at least some of them, and, are pre-assembled, taken apart, delivered, and then reassembled?
Sure. There are a variety of types of modular homes.
Is that a temporary, would that be a home of a temporary character because you could unassemble it again?
If it shared all of these same characteristics that the current modular home owned by Ms. Price contains, then yes. If it was built off-site and moved by trailer and easily removed from the structure in the same way that your average double-wide mobile home is, then yes, it would. But that has to be a case-by-case analysis as to whether or not certain structures fit within a given restriction. And the Supreme Court in Williams did exactly that. It looked at when the restriction was recorded, the legal framework that existed at that time, which was 1995, 10 years after modular homes came into a statutory existence. And it based its holding on that time and said, because these modular homes have existed for 10 years and restrictions are in similar neighborhoods are starting to include the language of modular homes, then the parties who recorded that restrictive covenant needed to use that language. But it did it based on the time in which it was recorded. And here, the time in which it was recorded was 30 years before modular homes came into existence.
Counsel, let me ask you, is the real question here whether or not this is the interpretation of whether or not this is a structure of a temporary character?
Yes, that is the key question, and we believe that it is.
Okay. Thank you. You've used your time. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good afternoon, Your Honors. I'm Brian Mansfield from the Sevier County Bar. I believe that the appeal is fairly easily decided with some fundamental questions. First, what is the difference between this home and the home in Williams versus Fox? I think the answer to that is nothing. Both are modular homes by design, by manufacture, by law. And the next question is, do the Fort Loudon Estates restrictions prohibit modular homes? They do not. Then the third question is, could they have? And the answer to that is yes, they could. What did the Tennessee Supreme Court tell us in Williams versus Fox? In sum, and I'm quoting from that opinion, we hold that modular homes are distinct types of structures from mobile homes and trailers. And because the restrictive covenant did not expressly prohibit modular homes, the plain wording of the covenant cannot be expanded to prohibit the defendant's modular home. Your Honor, Your Honors, I believe the inquiry should stop there. The Supreme Court has answered the question, and they have established a bright line. As Judge Sweeney, you noted, both the legislature and now the Supreme Court of the 2007 opinion have drawn this line and made the distinction. I would also submit to the court that there is a void on the part of the appellants to show by fact or law why this particular home should be treated as a trailer or a structure of temporary character, which of course would defy its design, manufacture, and designation by law.
Mr.
And
Mansfield, I have
the
a
appellant
question.
has felt,
Mr.
yes,
Mansfield,
Judge Davis.
do you think there are any circumstances under which a modular home can be considered temporary, or is a modular home, by the nature of what a modular home is, always going to be considered a permanent structure?
It's a good question, and I noted in my brief, I could imagine a scenario in which an owner would take a modular home and either it not truly be a modular home by some I don't know, distortion of the production process or the labeling or whatever, or they could somehow attempt to modify it and try to keep it on their property to make it temporary in nature. I don't know why anyone would do that. That's not the intent design of it, but I could see a scenario where that could potentially could potentially happen. So I wouldn't go so far as to say there could not be a scenario somewhere, somehow, where that could occur.
Position that in general, a modular home is built and intended and designed to be a permanent structure.
That's correct. I think by statute, and I think and the Fox case cleared that up. The appellants have exhaustively, because they have to, in order to prevail here, refer to this home as a temporary structure. That the appellant's home is a structure of a temporary character or trailer, but they submitted no proof of that. There's no evidence to indicate that. In fact, the only evidence at the hearing in this case that they really elicited to try to demonstrate that is this testimony that it could perhaps be moved. And had the witness say, well,
perhaps, counsel, I'm sorry, to be fair, it wasn't just that it perhaps could be moved. I mean, wasn't a testimony that sure you could reattach the wheels and whatnot and move it?
I think he did say that.
Okay.
I think he did say that. But in the same vein, Judge Sweeney, he also said, but look, that's true of pretty much any home. You can move a home, whether it be a modular home, manufactured home, or a rancher that was stick built. I mean, that was the point. And but yeah, I mean, he did say that. But then in their reply brief, the appellate essentially just discards that argument and acknowledges that, look, any house can be moved, and that's not dispositive of the case. The other thing I'd like to point out, and counsel didn't address it to a great extent, but this concept that somehow Williams versus Fox is limited to restrictions that would have been recorded after the adoption of the Modular Building Act, which was in 1985. That's just unsupported and just contrary to the opinion. Number one, the court did not limit its ruling. It didn't say that and did not purport to say that. Number two, counsel doesn't address the fact that the folks in this subdivision could have amended their covenants and restrictions by a mere majority anytime after 1985 or the decades thereafter, or after the Williams versus Fox opinion was decided in 2007, and could have specifically restricted modular homes. They had the ability to do that, and they elected not to do that, but they want this court and they wanted the trial court to do that. And thirdly, even if neither one of those things were true, the burden still remains upon the appellants to prove that the Ms. Price's home is in violation of the restrictive covenant at issue. They have to prove that Mrs. Price's home is in violation of the following language. Number 4, temporary structures. no structure of a temporary character, trailer, basement, tent, shack, garage, barn, or other outbuilding shall be used on any lot at any time as a residence, either temporarily or permanently. That's the restriction at issue. But what do we know about that? We know that this is not a structure of a temporary character. There's just no proof of that. In fact, the proof is that by design, manufacture, and by law statutory, and by legal authority through the Tennessee Supreme Court, it is not a structure of temporary character. And the chancellor so found that. He found there's just no evidence of that.
Mr. Mansfield, I'm sorry to interrupt you again. I know there's some discussion in the briefs about the foundation upon which a modular, could you remind me what kind of foundation a modular home has?
In this instance, I think it's a block foundation. I don't know if it can be put on a like a concrete slab. I don't know all the details of that, Judge Davis. My understanding is they're always to be placed upon a permanent foundation. However, I believe in the Fox case, that was actually a foundation with a basement. This one is not, but it's always it's like a stick-built foundation. It's going to be block, slab, basement, something like that. Okay. So the point I was going to make is we know based upon this restrictive covenant that it's not a temporary character. It's not a trailer. We know that. Not a basement, not a tent, not a shack, not a garage. It's not a barn or some outbuilding. So,
Counsel, do you agree that the same question I asked your opposing counsel there, the real question here we have under that number 4 is whether this structure is of a temporary character?
I think that I would say yes, Your Honor, but I think the answer has already been provided for us. I think that if it's a modular home, and unless
I understand your position, I understand your position that it's already been answered and all that it's not a structure of a temporary character, but that is the question. I mean, it's not that it's a trailer, a basement, a tent, a shack, a garage, barn, or other outbuilding. It's whether it's a structure of a temporary character.
Right. I think that's right, Judge Sweeney. I think that's correct. Okay. A couple other points, and then I'll just go ahead and finish. It's just a reminder, I know the court knows this well, that it is not for the courts to add to restrictions. And in essence, what the appellate wants to do here is have this court and one of the trial court to add to these restrictions modular structures, modular homes. It's inconsonant with what the restriction says. There's no legal basis to do that. And as we also know, that if there's any uncertainty or ambiguity in terms of what the restriction does and does not say or does and does not do, that is to always be construed in favor of the free use and against the restriction. I would note to the court, this subdivision is lightly restricted. It's not Getty's View or Belmead. There's very little in terms of construction or features or use restrictions. I mean, in this subdivision, you can have 900 square feet. You can have a mini house. You can have flat roofs. You can have chain link fences. You can have junk cars, and you can have chickens. So that's just the nature of the development. I would finally note that if we look at the record, the chancellor made, I believe, what the only decision he could make based upon the facts and the applicable law. And certainly, I do not find that there is evidence that preponderates against the chancellor's ruling in this matter. Accordingly, I would respectfully request that the appeal be denied and the case remanded. Thank you.
Thank you. Mr. Riley, we'll hear from you in rebuttal.
Thank you, Your Honors. Your Honor, opposing counsel stated that this subdivision is lightly restricted in that it allows homes of various sizes and chickens and et cetera. And that may all be true, but it does restrict structures of a temporary character. And nowhere in the Modular Buildings Act does it state that all modular buildings are permanent. It doesn't even use the word permanent in the entire statute. Further, nowhere in Williams versus Fox did the Supreme Court state that all modular homes in every situation are permanent. It found that in that situation, in interpreting a restrictive covenant recorded 10 years after the Modular Buildings Act, that modular home was not prohibited by that description. Further, it left intact the entire line of cases that came before it and cited to those for the law and how to interpret these restrictions. And all of those cases remain good law, which was confirmed by the Court of Appeals in Napier later on. Further, opposing counsel stated that there's no proof in the record that this is a structure of a temporary character and that there's no evidence for that. However, the evidence is overwhelmingly clear that this is a structure of a temporary character. That language, structure of a temporary character, has been found by previous appellate courts to include structures of various types that were built off site, moved by tractor trailer, assembled on site, can have the wheels and tongues reattached and easily moved like a typical mobile home. And the evidence was overwhelming that that is exactly what this house is. Whether it's modular or not, it is a structure of a temporary character and is prohibited by this restriction. The trial court.
I'm sorry. What proof, other than the fact that the wheels can be reattached and it can be moved, shows or supports your client's view that this is a temporary or structure of a temporary character?
Your Honor, the primary factor that courts have looked to in this long string of cases is that it is built off-site. In Williams, even in Williams versus Fox, the Supreme Court referenced this intent of builders to keep homes that were built off-site from being transported to the lot. So this home was built off-site, exactly like a mobile home would be. It was put on two different trailers and transported in separate pieces and assembled on the lot, and then placed onto a foundation once it arrived. So not only can it be removed in the same way that a standard mobile home or other structures of temporary character would be, but the assembly of it, the construction of it, and how it arrived at the lot all point to how and why this is a structure of a temporary character. And for these reasons, we ask that this court reverse the holding of the trial court, remand for an injunction prohibiting Ms. Price's modular home, and refund of the injunction bond. Thank you.
Court's thanks to all counsel. We appreciate your oral arguments today and your briefs on this. I think we understand your positions on these issues. If you would, please recess court till tomorrow morning.
This honorable